When Attorney General Pam Bondi announced the release of the Epstein Files Phase 1, expectations ran high. Would the long-awaited documents expose new details about Jeffrey Epstein's powerful network? Would they finally provide answers about who knew what and when? But instead of a bombshell, the release landed with a thud. The binders, distributed exclusively to conservative media figures at the White House, were heavily redacted and contained little information that wasn't already public. Frustration over the anticlimactic nature of the documents has dominated headlines, with commentators and lawmakers alike expressing disappointment at the lack of meaningful new revelations. And so we are left to ask, what exactly was the purpose of drumming up excitement just to disappoint? Is this simply another incompetent Trump misfire? Hardly. The point was never the contents of the Epstein files, now scrubbed and sanitized by administrations of both sides. The point was how they were released. To set an outrageous, unconstitutional procedural precedent in plain sight, while everyone is more distracted by the obvious lack of any substance. Let's dig in. The Department of Justice, bound by principles of fairness and transparency, selectively handed over these documents to politically aligned media figures rather than making them available to the public. While perhaps not compromising investigations by containing no new material, his unprecedented move raises serious legal and ethical concerns, from the violation of federal transparency laws and legal authority, to violation of equal protection and due process, to misuse of public office, to the Hatch Act and the exchange of access for compromised reporting. What it comes down to is this. Have we just witnessed this administration set a clear precedent for the selective disclosure and politicization of public records? These questions are far more consequential than whether the release lived up to its hype. The focus should not be on whether the Epstein files were juicy enough, but on whether the Justice Department just rewrote the rules on transparency, fairness, and the integrity of public information. The decision to release the Epstein files in such a controlled and partisan manner is not just an isolated controversy. It is a fundamental challenge to the principles of government transparency, equal access to information, and the impartial administration of justice. The Department of Justice does not typically function as a selective distributor of public records, nor does it operate as a political press office. Its credibility rests on the notion that information is released based on legal standards, not political convenience. By departing from this norm, the DOJ has raised serious concerns about whether it is still acting as a neutral arbiter or if it has begun curating narratives for partisan ends. This selective disclosure also undermines public trust in the integrity of government institutions. The Epstein case is already fraught with speculation, conspiracy theories, and accusations of elite impunity. When the Department of Justice handpicks which journalists get access to documents, especially in a case of such high public interest, it fuels suspicion rather than dispelling it. Was information withheld to protect certain individuals? Were politically friendly media figures given a chance to shape public perception before the full story could be known? By failing to release these documents through normal channels, the Department of Justice has ensured that these questions will linger, feeding precisely the kind of uncertainty and distrust that transparency laws are designed to prevent. Beyond public perception, this move also sets a dangerous precedent. If the government can selectively disclose investigative records to favored media outlets, what prevents future administrations from doing the same for other politically charged cases? Could officials withhold damaging information from unfriendly journalists while strategically leaking documents to allies? If left unchallenged, this practice could erode the principles behind the Freedom of Information Act and open the door for government records to be wielded as partisan weapons rather than public resources. This is why the selective release of the Epstein files is not just a minor misstep. It is a significant breach of norms with wide-ranging consequences. The question is no longer just about what is in these files, but whether the government has abandoned its obligation to distribute information fairly, impartially, and in accordance with the law. The Department of Justice's handling of the Epstein files represents a clear departure from established legal and ethical norms governing the release of government records. These norms are not arbitrary. They are rooted in statutory law, DOJ policy, and constitutional principles designed to prevent the misuse of official information for partisan or personal gain. By selectively providing Epstein-related documents to politically aligned media figures rather than releasing them through standard DOJ channels, Attorney General Pam Bondi has not only violated long-standing practice, but also raised serious legal concerns regarding fairness, transparency, and due process. Federal law provides a clear framework for how the DOJ should engage with the press and the public when releasing information. Under DOJ Media Relations Guidelines, 28 CFR Section 50.2, officials are required to maintain fairness and impartiality in public disclosures. Selectively releasing investigative materials to a subset of media figures, especially those with a known political bias, raises clear concerns about viewpoint discrimination and the potential for media manipulation. Furthermore, under the DOJ Justice Manual, Section 1-7.000, employees are prohibited from making public statements or releasing materials that could compromise an ongoing investigation or unfairly impact individuals who have not been charged with a crime. If the Epstein Files include names of uncharged individuals, the decision to provide these documents exclusively to media figures with financial and political incentives to shape the narrative may have violated this policy. Beyond DOJ regulations, the Freedom of Information Act, 5 U.S.C. Section 552, provides the statutory foundation for equal access to public records. While FOIA contains exemptions for law enforcement sensitivity, privacy, and national security, it does not permit selective disclosure based on political favoritism. If the documents were suitable for release, they should have been made publicly available, not handed off to a select few. The decision to provide privileged access to certain journalists while withholding the same records from the broader press and public contradicts the core principles of FOIA and undermines the legitimacy of the release. More broadly, the DOJ's actions raise constitutional concerns under the 5th and 14th Amendments, which prohibit the government from favoring or disadvantaging individuals or groups in a manner that denies equal protection under the law. If media access was granted based on political alignment rather than neutral criteria, it could constitute an unconstitutional use of government power. Similarly, under Title V Code of Federal Regulations, Section 2635.702, federal officials are explicitly barred from using their position to grant preferential treatment to any individual or group. Providing exclusive access to media figures with financial incentives to shape coverage in a way favorable to the administration could violate this rule, as well as raise concerns under federal anti-corruption statutes such as Title 18 of the United States Code. These precedents exist for a reason: to ensure that government records are not wielded as partisan tools. The Department of Justice's departure from these standards has immediate consequences for public trust, investigative integrity, and the rule of law. If allowed to stand, it would set a dangerous precedent where public records could be strategically weaponized by those in power rather than serving their intended purpose, ensuring transparency, accountability, and equal access to the truth. The selective release of the Epstein Files is not just a misstep, it is an abuse of discretion that undermines the foundational principles of transparency, fairness, and equal access to public information. By sidestepping established Department of Justice protocols and selectively providing documents to politically aligned media figures, the Attorney General has signaled a dangerous shift, one in which public records are no longer public but rather controlled assets to be distributed for partisan advantage. This is not how a democracy should function. The Department of Justice is not a political communications shop, nor should it operate as a gatekeeper, determining which journalists are worthy of access to public records. When a government agency withholds information from independent and critical voices while selectively empowering favored media figures, it is no longer serving justice. It is curating narratives, shaping perceptions, and controlling the flow of information in a way that is antithetical to its mission. The precedent being set here extends far beyond the Epstein case. If left unchallenged, this practice creates a template for future administrations to manipulate public records, withholding or strategically releasing information based on political convenience rather than legal standards. Today, it is the Epstein Files. Tomorrow, it could be investigative findings on government corruption, law enforcement misconduct, or any other politically charged issue. The question we must ask is simple. If transparency can be subverted so easily in this case, what stops it from being subverted in all cases? The damage is not just theoretical. By handling the Epstein Files in this manner, the DOJ has fueled distrust rather than dispelling speculation. A case that has already been marred by secrecy and elite impunity now carries another stain, the suspicion that even in disclosure, the government is still hiding something. The irony is stark. A release intended to demonstrate transparency has, through its execution, achieved the opposite effect. This is why outrage over the lack of new revelations in the Epstein Files is misplaced. The real scandal is not in what was or wasn't in the documents. It is in how they were distributed. The focus must now shift from the content of the files to the integrity of the institutions responsible for their release. If we accept this as the new normal, we accept a future in which public information is no longer public at all. That is not a reality we can afford to tolerate.